Today in this video we are going to discuss about Civil Procedure Code 1908, in which we are going to discuss the particular topic interrogatories, that is dealt in Order 11 Rule 7 and 8. Interrogatory என்பது ஒரு டிஸ்கவரி என்ற தலைப்பின் கீழே டிஃபெண்டண்டோ பிளான்டிஃப் ஆர் டிஃபெண்டன்ட் எதிராளியிடம் மீது கேள்வியை கேட்டு அதற்கான பதிலை பெறுவது. அதே போல் டிஃபெண்டண்ட்டும் பிளான்டிஃபிடம் கேள்வியை கேட்டு அதற்கான பதிலை பெறுவது. இது கோர்ட்டினுடைய ஸ்பெஷல் பர்மிஷன், அவருடைய அனுமதியின் பேரிலே நடக்கிறது. இதனுடைய முக்கியத்துவம் என்னவென்றால், அவ்வாறு அந்த கேள்வியை கேட்டு அதற்கான பதிலை வாங்கும் பொழுது அவருடைய வாதத்தை முன்னிறுத்தி வெற்றி பெறுவதற்கோ அல்லது எதிராளியை தோற்கடிப்பதற்கோ அது பயன்படுத்தப்படலாம். அதே போல் டிஃபெண்டன்ட் பிளான்டிஃபிடம் கேள்வி கேட்டு பிளான்டிஃபை தோற்கடிப்பதற்கோ அல்லது டிஃபெண்டனுடைய கேஸை நிலைநிறுத்துவதற்கோ இதனை பயன்படுத்தலாம். We will go in in-depth study of this interrogatories. So first we will see the nature and scope of interrogatories. Actually, interrogatories means the questions for further action. It may be the questions may be asked on either side, from the plaintiff side or from the defendant side. So it has to be answered by either party. Otherwise, the court will take the nature of the why they have not answered the questions, and accordingly it will be decided. Suppose if the defendant is not answering, then it will be, the case will be favored on the plaintiff, and in trial proceedings it will be decided on the plaintiff side. So it is to give chance to each other to explain their case, and also for that the answers should also be given. This can be done with the permission of the court. அவருடைய கோர்ட்டாருடைய சிறப்பு அனுமதியின் பேரில் இது செய்யப்படுகிறது. கேள்வி கேட்டு அதற்கு பதிலாக பெறுவது நடைபெறுகிறது. அடுத்ததாக ஆப்ஜெக்ட் ஆஃப் இன்டராகேட்டரிஸ். The object of interrogatories is one, to enable party to require information from the other party to maintain his case or to defeat the other party's case. So that is the two important thing that can be mentioned in objective. That is, one is to win his case through the interrogatories or to defeat the other party. That is the main objective of this interrogatories. Then form of interrogatories. The interrogatories are to be expressed in the order form number 2 in appendix C. So provision has been drawn from order 11 rule 4. Then we will see the interrogation which may be allowed. What are the interrogations which is allowed? That is, for that a case study illustration is Raj Narain versus Indira Gandhi 1972 in Supreme Court 850. That is, in this what it has been decided that do not touch the core questions, do not touch core of questions, but they must be held as oral evidence. So according to this decision, it is held that don't go to the core of the questions. It can be taken as a oral evidence according to this Raj Narain versus Indira Gandhi. Actually, in this case, what it has been decided, the Raj Narain win over the election, in the MP election, and that was the case. And do not touch core of questions, but they must be held oral evidence. And interrogation which may not be allowed, which allowed, we are going to see, which may not be allowed. Certain questions interrogatories cannot be allowed by the court, that is relating to evidence of the case of his adversary. So it should not be pertaining to evidence, and then relating to confidential, some of the confidentiality should not be questioned, and privileged communication, privileged thing should not be questioned, that is interrogation should not be done, and then disclosure which is injurious to public interest. Suppose if the disclosure is injurious to public interest, it should not be included in interrogatories. Then scandalous, if the interrogatory is scandalous, that is not allowed. And then really in nature of cross examination, and then on the question of law, it should be on the question of law, and fishing in nature, if at all if it is fishing in nature, it is not allowed. Then prolix and oppressive nature of interrogatories is not allowed. Then rules to interrogatories. What are the rules adopted in interrogatories? That is, it administrates in writing, and it should be in writing form. It should not be oral, and subject to court conditions. The court allows it, then it can be done. Then should be submitted to court. So actually it should be submitted by court, and the court should permit it, and then administered by the either plaintiff or defendant. Both the chance is given to both, either to the plaintiff or to the defendant. Both can go for interrogatories. Plaintiff can go for interrogatories with the defendant, and the defendant has to answer it, and the defendant can put interrogatories on plaintiff. Objection to interrogation by answer, that is what are the things considered as relevant by court, that is allowed, and what are the things interrogatories is objectionable, that is not allowed by the court. Then when interrogations are permitted, section 30 clearly indicates our provision has been given by section 30. Court has got power to order discovery or permit interest at any time. Order 11 Rule 1. That is, it is the leave of the court. Either it can be allowed or it cannot be. It can be disallowed. So court has power to order discovery or permit interrogatory at any time. So that is it is the special leave of the court. So our court today சிறப்பு அனுமதியின் பேரிலே இது நடைபெறுகிறது. So according to section 30, court has got power to permit or to not permit, setting aside and striking out interrogation. Sometimes it set aside the or strike out the interrogatories. Interrogatories are not allowed. Striking the interrogatories, provision has been laid down in Rule 7 that they have exhibited unreasonableness. Suppose if the interrogatory is unreasonable, the liability is unreasonable and prolix and suppressive nature and scandalous nature, that is not allowed. So such of those questions, interrogatories are struck out by the court. Then appeal, an order granting this interrogatory, granting or rejecting prayer for interrogation, either allowing or disallowing, it cannot be taken as neither a decree nor appealable order. So it cannot be taken as a decree, court order or appealable order. Hence, no appeal lies against the against such orders. So if the court giving order for interrogatories, that cannot be construed as the order for appeal, or it cannot be taken as a decree. So no appeal lies on it. That is the thing behind it. It is with appeal. So with this we conclude the interrogatories which is spelled out in order 11, rule 7, 8, and also section 30 also spelled about the interrogatories.